Say hi.
You got it?
Yeah, you're good.
Press one button, Robert.
Okay.
You can handle it.
Fred, do you want me to pick it up or something?
I'll let you know if I need to, but otherwise.
Yeah, okay, text me or call me, I have my phone. If you're not coming, I'll grab it all, I'll throw it in the car, and we'll get it another time.
Okay, thanks.
All right, thanks. Fred, let me ask you something else.
Yeah.
Okay, so I'll email you this week.
Okay. Okay.
So I'll email you for that.
We're going to do the area too, right?
Yeah, we'll get
General area.
So we
I'm
go.
not gonna be able to make that date.
I'm gonna email you for that.
Yeah, so, like, every time I said it,
So we're all on it.
And I'm reminding you to do what?
because I'm not
Yeah, this is actually a super important piece of information for those of you that are basically going to be in the program past June. We just got word this past week that the university is switching from a quarter system to a semester system. That will go into effect in basically August of this next year. Now, how it will impact you is going to be relatively minimal because I've readjusted the schedule to deal with this. Everything will be normal, completely as it has been in terms of timing, sequencing, courses through June, okay? July and August is going to be weird, okay? July and August, we will not have any scheduled classes, okay? In July and August. What will happen is the courses that were scheduled for July and August are being shifted to late August, early September. So you will have effectively a summer gap, okay, for this next year. Once again, this only affects those people that are effectively not completing the program by June, okay? Everybody follow me on that? Yes? Okay. And so it'll still, and even after that, it will still be a year-long program. It's just that everything is being crammed into a semester, and it actually works out a little bit better for folks because what will happen is, right now we're meeting on effectively 40 out of 52 Saturdays over the course of a year. Under the semester system, the program will actually be meeting 46 out of 52 Saturdays. And the difference is really the days will be a little bit shorter. That we'll be meeting from about 8 o'clock to about 4:30, okay?
I just heard that, half an hour shift.
Yeah.
So like for me, I started last quarter.
You guys are lucky,
Always
man.
on the end of that has no effect on it. 'Cause
Correct.
It's done during June.
Correct.
I guess
It really only affects the people that literally just started the program this semester. So Tyler, Daryl, Johnny,
We get a summer and then.
who else?
And then we gotta
Yep,
finish it up.
Kimberly.
So the land use class, for example, that I've been taking, I'll have to take it when?
I will get, as soon as we finally have the actual days, I can kind of let you know which semester, I can let you know which semester it's going to be in. What I don't have is the precise date as to like what week that it's going to be, but the semester, let's see. It looks like that the Lautenschlager's land use regulation course would be offered in probably be roughly October. It'd be like October, like just middle of October. So, and then after that it would be done. Okay.
quickly before you get out of here, regarding walking, so to speak, I'll be done June 20th. How does that coincide with?
I don't know, and I don't have the answer to that. You know, obviously, the university only has one graduation ceremony per year, and it's like June the 11th, I think it is. I don't know whether they allow folks that have not officially completed the program to walk.
Okay.
That's just a question I don't have an answer to
All right,
yet.
no problem.
I'll try to see if we can find that out. Okay, anything else? Okay,
Is it like late August, is that when the term officially begins?
right,
Very late August, I think.
right.
Probably before the holidays.
It just be more normal in the sense of kind of a normal semester term.
Which is what the undergraduates are on right now.
Correct, correct.
Hey, you and Nicola have the same shoes on.
Why? Why are we
You and Nicola have the same shoes on, man. Fancy, you guys are fancy. You guys are fancy.
Come over here.
One question. Today's my son's mother's birthday.
She has a name, right?
Son's mother.
Thank you, Becky.
Ryan's mom. You want to see her name?
Becky, happy birthday.
Educational purposes.
Happy birthday.
Let me show my son says
Even
happy
want to be
birthday.
something cool like that.
Card and stuff.
When he gets older, sounds older, requests to do stuff like that.
We don't know right now. Take him over there, like, tell me who's Carter's mom.
I'm gonna fly to San Francisco.
People want to just suffer. It does.
I don't.
I'm like project coordinator. Sometimes I'm like this project.
That leads to bring
I've written.
So I'm doing all the same.
Yeah. Bring a lot.
Thank you very much.
All set? Good, glad you did.
I got the 8 process. No, you can eat it. That's
Not anymore.
I was actually looking for one PhD. No,
It's not.
It's me learning how to read.
Is that you're teaching, well, Ryan's teaching him how to read.
My son is reading. I took a video of him reading.
Ryan's teaching his dad how to read.
My phone is emotional.
I gotta bring that piano around.
What's she doing now?
Summer.
She calling you? She got calling you?
She's practicing calling right now.
I can follow you. Follow you. Yeah, he's just right.
like baby college college.
Good job, honey.
We've come so far.
Aw.
When I first started like putting words on index cards for him and stuff. Now he's reading.
He's all age.
He officially said he could read yesterday.
No, what's funny is that there's a little, my cousin has a that came out of house and she's
I'm good now.
Good. Hey, Pete, we've got 2 to go.
My I met with his teacher.
They're outside, they're still, they're here.
And
You said-
she was just, you know,
Yeah, they're here, they're just in Starbucks.
At Starbucks, did you say, or outside? Which did you say?
Starbucks.
Starbucks, is that in the building?
Nope, she did some
extra words now, because.
But they're definitely here, that will be a good start, that's cool.
87 words on it. And that was what he was supposed to, yeah, it was, but that's what it was. And he was supposed to go through those words.
Mark, would you start that roll sheet?
And just took those, he knew some of them, because I had started with him over the summer. But we were just taking like 5 words a day.
Okay, good morning, folks.
So we just, he's there, and I love it.
Proud of you. Becoming an adult.
I'm proud of my little man.
Um,
My little homie.
Sorry we're here on such a pretty day, guys. I'd like to be out there too. We'll get her done by 4:30 no matter what. Leave a little bit of the good day. I want to start with, we're talking about our quiz from last week. Our practice quiz. Everybody, as you're here, please just take yours, pass them on. Separately, Mark has started the roll sheet around. We're going to sign in a roll for any of you who aren't here and get that back to me if you would. Sign somewhere next to your name. So I'm required to keep attendance for the university. And once everybody has their quiz back, I want to talk that through a little bit, give you my thoughts, tell you what I thought we were looking for, let you ask any questions. Does anybody still not have a textbook? Everybody good? Excellent.
I actually have 2 textbooks.
I'm sorry?
I have 2 now.
You have 2. So you can be the guy loading up people. Okay.
That other one, they said they were going to deliver it, and then they gave me a new delivery date, like the
Cool.
20th.
Well, did they send you an 8 by any chance?
So then I found the 8 version, which I just got the other day.
Yeah.
And then this came in the same time my other one came in. So I have a 7 and an 8 of new one.
Okay, doke. If it's of any consolation to you, we'll probably use in the 8th next year, so maybe you can sell that new book to somebody. Not me, they gave me a free one. All right, does everybody have their quiz back? Anybody not? Are they not around yet? Still go? Okay, the pile, I think the pile is here and they're coming back. All righty, let's talk about the quiz. Everybody did well. I was impressed with the answers. I have a couple of comments that I'd like to make of what I wanted to see. And as to those of you who are disappointed in the grade, I'll tell you what I was looking for. But there were a lot of A's, a lot of people were paying attention, and I'm pleased because a lot of the stuff is stuff that we just talked about in class. It wasn't in the book. And that's the way it's going to be going forward. If you miss class, you're going to miss something that's going to be on the exam, period. And I know you know that next week we're having a midterm. So I hope that this practice quiz will be kind of a learning session for you as to format and as to when I tell you the kind of answer I was looking for, then you'll know where my head is. Okay, first, 2 not back yet.
Yeah, come on. Frederick Jackson.
Just got here? Okay, cool. Thank you. Okay, first comment I want to make was I really meant it about the space provided. And I'm going to enforce this going forward. The format of the exams is going to look like this. If you write anything on the back or on another page, I'm not going to read it. So if you choose to do that, put your important stuff up front, because that's what I'm going to read. I know in a lot of these subjects you could go on and on ad nauseum, but I'm looking for the high points. I'm looking for the biggies. And those are what I'm going to add up the score on, of how many of the high points did you get and not how much of the junk between the lines that might end up on the second page. I want to talk first about this one about the federal courts, Florida courts. I want to say first that obviously a lot of you got fooled by the fact that it looks like there's 4 levels here. There's not 4 levels. There's 4 colors. I'm sorry for that. I meant to go back and watch the video because I'm confident I said this 4 or 5 times. and I'm going to say it again. There are 3 levels of courts. 3. 3 in the federal system, 3 in the Florida system. Here's what's going on here. The first level is the trial court. You go one place or the other. You go to the county court or you go to the circuit court. But either way, that's your trial court. So this is not 4 levels, work your way up the feeding chain. It's 3. Federal system and Florida system. You pick a trial court based on your subject matter or your amount in dispute. You know, your small claims or your 5 to 15,000 or you're over 15,000. But then you're in one of the trial courts working your way up. So, again, I apologize for the confusion that this looks like 4 levels. And I agree it does. That's not what I was looking for. I'm looking for 3 levels. The 3 levels are the trial court, federal and Florida both. I ask you to ignore the precise court names. I got a lot of circuit court, district court, that's not what I'm looking for. I don't expect you to know that. I expect you to know there's a trial court. Whichever one it is, it's a trial court. Whatever its name is, whatever its level is, you got a trial court. And I ask you for a description of the functions of each. And the function is what I was really looking for. I inartfully worded this where I said and or the types of cases heard. A lot of people got off into the types of cases heard. You know, this is misdemeanors and this one's felonies and this is this. What I was really looking for is the functions, and going forward in terms of your responsibility, I want you to know the functions. The function of the trial court is threefold. Listen to or hear the evidence. That's the witnesses. That's the exhibits that people introduce. Listen or hear the evidence. Secondly, make findings of fact based upon that evidence. The trial judge says, I find that the defendant crashed his car into the plaintiff. That's a finding of fact. That's important because as we go on up the chain, that's no longer in dispute. The trial judge has made a finding of fact. And the third thing the trial court does is apply the law to that finding of fact. Now, it may be a jury in the trial court. Remember, it could be a jury, could be a judge. Going to listen to the evidence, going to make finding of facts based on the evidence, and then is going to apply the law. And that's what happens in the trial court in either system. Next step up is the intermediate appellate court. The intermediate appellate court does not make any finding of facts. It accepts the finding of facts as determined by the trial judge. It's not seeing witnesses. It's not hearing testimony. It knows that the trial court or jury did, and it will leave that intact. It will not disturb the finding of facts. But the big thing that it does is determine, was the law correctly applied to those facts? Those facts are decided, and was the law correctly applied? And lastly, and perhaps most importantly going forward, is it writes an opinion. It writes a published opinion. And that published opinion becomes precedent. It's published. People can find out, okay, under this set of facts, they can go look up, this court has ruled this is what's going to happen. And that's going to control the courts down below. So really kind of 2 things that it does. It determines whether or not the law was applied correctly. And based on that, it'll affirm, it'll reverse, it'll send it back for trial, it'll take some action. But secondly, and most importantly going forward, it will write an opinion for everybody to be able to review and find out what the law is going forward.
So a case will never,
I'm sorry?
a case would never go there first.
I'm just sorry, I'm not
A
following.
case would never go there first.
A case will never, what I'm just sorry.
Go to the appellate court.
Goes for the
That's what he
appellate
said.
court first.
Oh, absolutely not. No, no,
But
no.
it would- it could-
You have to go to a trial court first.
Yeah.
You cannot go directly to an appellate court. An appellate court means it's hearing an appeal,
Yeah.
and an appeal comes from a prior court action. So everybody starts in the trial court at every level. Which trial court is based on your situation, or your dollar amounts, or even in federal court, as you know, maybe based on diversity, maybe based on a federal question. There are other ways you get into federal court, but you always start at the trial court. And the whole concept of an appellate court at the next level is, it's hearing an appeal. One of the parties wasn't happy. Good morning. One of the parties was not happy and decided to have an appeal, to take an appeal up to the next level. Good morning. So there's already been a trial. Now, the top level in both systems is named the Supreme Court. And its functions are identical to what we talked about for the trial court. To what we talked about for the intermediate appellate court. Identical functions. It's going to see whether the law was applied correctly by both courts below. It's looking at two courts. It's looking at what did the trial court do? And then it's looking at what did the intermediate appellate court do as to the trial court. It may have said go back and have another trial. Well, if the parties appeal again and manage to get the Supreme Court's attention, then it decides, did the appellate court rule correctly? So every appellate court rules on the actions of the court below, and every appellate court writes opinions, and those opinions are precedent, and precedent is what tells us what the law is. Remember, we had 4 sources of law, and one of the sources of law was court-made law, and that court-made law is precedent, and that's where these come from these opinions written by an appellate court. Yes, sir?
So does the Supreme Court ever, I guess, tell the legislature to change or to clarify
No.
future laws because they've had a lot of issues with the understanding of the way the law was written, or?
They say in their opinions, gee, it sure would be helpful if the legislature would clarify this, but they have no authority to tell the legislature to do so.
Right.
They say this is really vague, this is a brand new statute, we don't know what it means, here's what we think it means, but we wish the legislature had written more clearly. But the legislature is very jealous of its function and of the interference of the courts in its legislative function. And there is no direct authority for the courts to instruct the legislature to pass some new legislation to clear it up.
So they don't have like a lobby that lobbies a?
No,
Right,
there
that-
are lobbyists for all of the people who are interested in what the legislature's doing.
Right, but I mean,
the
as far
only
as, like-
lobbyist that the Supreme Court has
Yeah.
is more money, more funding, more money for judges, more money for clerks, more money for appellate courts, more money for trial courts. The state court system has lobbyists, but all they're lobbying for is court structure and court funding. But they're not lobbying to make the legislature clear something up because it's
Okay.
making our job as judges tougher having to unsnarl it all.
Okay.
They don't have that authority, and that would be considered gross overstepping by the legislature and meddling in their function. Legislature resents it greatly when the court finds something they've done unconstitutional. Sometimes they'll come back and do it again and again because they think they're right and they think they're driving. And the court says, no, what you did violated the Constitution. The answer is no. So we have history where it's come back 2 or 3 times, and each time the court has said no. And there's some real friction there because the courts are kind of overlooking what the legislature's doing, and they don't like it. They think we're the ones who were elected to make the laws, we the legislature, and we don't like the judges telling us we can't do this or can't do that.
Can you give a thought as to why law is written in the language that it's written? Because it's not English.
Written by lawyers.
You know, like, why is it written to be so,
Obtuse?
yeah,
Confusing?
so abstract?
They think it's very clear. remember where a lot of law comes from. I say, of course, it comes from the legislature, but a step back further from that. Legislation is initially written by lobbyists who take it, mobile home lobbyists who wish the mobile home law would say, we don't have to have hurricane tie-down straps because it's expensive. They write up a bill like that. And they take it to their local legislator. And they take it to all the legislators that they've been given money to. Say, this is a great idea, would you introduce this law? But the point is, the law is not really written by Representative Joe Blow from Dunedin. It's probably written by one of his constituents or a lobbyist. And it goes through committees, and at the committees, they think they're going to clear up any ambiguity, but different legislators at the committee say, I want to have an amendment for this, and I have an amendment for that, and you get this thing that's all kind of cut and pasted, where going through, some legislation goes through 2, 3, 4 different committees because the subject matter touches on each of those committees, and they each add amendments.
Right.
And then it all gets to the floor that way, and sometimes it's all pasted together, and it just doesn't make any damn sense at all. But there'll be some good stuff in there, and for that reason, hopefully, it'll get passed. And then hopefully, although the governor may think it's confusing as hell, if there's a few good things in there, he'll have to sign it or veto it. Can't kind of piecemeal veto it. Got to veto the whole thing if he doesn't like, if you think it's too bad. But the point is, a lot of bad stuff gets in, piggybacked onto good stuff. And then that's the law. And it passed, and then everybody reads it and goes, what are we supposed to do now?
Because if you go as far back as like the Constitution itself, you know, why should it have to be analyzed for understanding? It should just be in a plain sense where this is what we're trying to tell you.
Remember also, the Constitution was written many hundred years ago when people talked a little differently than we. Certainly amendments get clearer. As amendments are current. You know, hopefully they speak in a little plainer English. I don't have a good answer for you other than what I've said already. Part of it is because it's just all kind of cut and pasted and put together, and it's based on political deal making. You know, well, if you'll put this provision in your bill, and I'll vote for it, but I want you to vote for my provision over here on this bill, and all these things get cut and pasted together, and that's the way they come to the floor. And they come to the floor on a basis of, do you want to pass it or do you want to turn it down? And hopefully most of the time there's more good stuff than bad. Virtually every year that there's a new substantive piece of legislation coming out of the legislature, the next year there's something called a glitch bill. And that's to clear up stuff that is already called to their attention as being a problem. Because by next year, stuff is not going to have made it through the appellate courts yet. For an appellate court to have already said, this is really vague, we don't know what it means, for the courts to say that. It'll be 3, 4 years before there'll be an appellate court opinion on this new law. But people in the industry, constituents of legislators that are affected will be calling their legislator and saying, hey, what you guys just passed didn't make any sense. You need to change this, you need to change that. And if that sounds good, somebody will introduce a bill the next year, and if that all sounds like it makes sense and it adds clarity, they'll pass it. But remember, every time you change something, every time a glitch bill comes in, somebody's ox is getting gored by that. Somebody doesn't like that. It's going to take away something. So there's going to be lobbyists fighting and taking representatives out to dinner and saying, no, you need to do this, you need to do that, and then they vote, and that's the legislative process. And that's how we get a lot of laws that just aren't clear. It's not a perfect process, but it ain't going to change either. As long as we have lobbyists who write bills, and as long as we have legislators who listen to their constituents who may have differing opinions, and that's always going to be the case. But it's the kind of stuff we're going to end up with. Hopefully glitch bill makes it a lot clearer the next year. And then hopefully after that, court opinions tell the legislators that this wasn't clear, it'd be nice if you clear this up. And hopefully that's well received and they'll do it. But again, it's not really well received because it's judges bossing the legislators around, and they think they're pretty big shots and shouldn't be told what to do. So
So the
It's not
glitch bill
always
is
well
just
received.
like a revision.
I'm sorry?
A glitch bill is a revision of the bill
Yes, yes.
and the year that passed.
Yeah, exactly. It's usually when there's a big comprehensive piece of legislation, like we talked about last time, the Condominium Act, when they first passed that. Oh my God, it's just full of nightmares. Next year, they pass a glitch bill that all it does is says amend this section to say this and amend this section to say that and try to clear up the ambiguity. So people have some idea of what they're doing. Okay, that was the first question. Court system. Second question was life estates. Let me tell you what I was looking for. And let me say to you that if you want to do really, really well, read every word in the question. And you're going to be 3 or 4 parts in each question, and make sure you answer all the 3 or 4 parts. If you skip one, you're automatically off a certain percentage of the answer. First thing was, what is a life estate? You got to tell me what it is. A life estate is an estate that gives possession in land for the life of the person who receives the life estate, measured by the life of the person receiving the life estate. Next question was, how does it differ from a fee simple? Well, a fee simple is all of the rights you could possibly have in land with no limits. Therefore, it's not measured by anybody's life. It can be indefinitely. It can be passed on family to family, etc. The 2 biggest differences, as I see them, are when you have a fee simple, you have all of the rights in the property, and you can do whatever you want to. You can dig holes, you can tear down buildings, you can do any damn thing you want to. Whereas with a life estate, there's a remainder man out there. The remainder man is who's going to get the property back at the end of the life estate. The life tenant is restricted by not wasting the property to the detriment of the remainder man who will receive it upon the life tenant's death. That's one big difference. Fee simple, you can do whatever you want to. Life estate, you may not commit waste that is going to damage the property when it's received by the remainder man. And the second big difference is you can will the property. If you own fee simple, you put it in your will. You decide where it's going. If you don't put it in your will, we have what are called intestacy laws. It's called intestate succession. All that means is if you don't do a will, we've got a statute that decides. It goes to your wife and kids. It goes to your brothers. It goes to your parents. Right on. If you don't have a will, we have a pecking order and statute. In either event, the point is, upon the death of the owner of the fee simple, he is going to have decided where the property goes. He's going to have decided by doing a will, or he's going to have decided by not doing a will and letting the statutes take care of it. But either way, he's made the decision. But with a life tenant, he doesn't will. The decision's already been made. There's a remainder man. He's already been determined, and that's where the property is going. So if a life tenant does a will and mentions this piece of property in which he has a life estate, not happening. Okay? Those are the 2 big differences. Waste and on your death. What happens to the property on your death? Okay. We said other than occupy the property, what else can you do with a life estate? Now, of course, if you didn't realize that in a life estate you could occupy the property, then there's something built right in for the first part of the question. What is a life estate? You get to occupy the property. So we've said you get to occupy the property. But what else can you do with it?
Rent it.
Sell it? Mortgage it? Lease it? Just like the fee simple guy can do. The only thing you can't do is will it. But what you can do is sell it, mortgage it, or lease it. Is that very marketable? Why or why not? No, it's not very marketable. Who wants to buy from you a piece of property where the rights are all gonna go away when you, the seller, die? The reason it's not marketable is because whatever you take from the life tenant, it's still measured by the life of that life tenant. Not measured by your life now. Still measured by the life of that life tenant. So if you pay him for the property and he dies next week, you paid for a week. You take a mortgage from the guy and he dies next year, and he doesn't, of course, then his estate doesn't make the payments, the bank doesn't have anything to foreclose on, because all the best I've ever had was a life estate, and that's gone. And if you lease the property, it makes a little more sense. At least it's sort of a pay-as-you-go. Keep paying your rent every month as long as the guy's alive. Well, at the end of his life, you lose your right to lease the property, but at least you haven't paid for something out there that you're never going to get. Yes, sir.
If you enter into a contract with like say a lease, so to speak, for a 10-year lease with this guy who has a life estate, but then he does die before this 10-year lease is up, and the remainder man takes possession of it, is that contract void at that moment?
Yes, yes, the remainder man is not bound by that lease. Now, that's going to get confusing in a minute when we get into leases, because the answer is different there. And I'm not going to go there yet, but the point is I want you to realize that answer that I'm giving you is limited to a life estate. If you took a lease from a life tenant, the longest the lease could ever last is his life, no matter what term you said the lease was.
And if you were not aware that this was if it wasn't made aware to you that it was a life estate, and you went in under the impression that this was a fee simple estate,
You made a mistake.
okay.
Too bad. That's why you need to check out, does the guy who's leasing you the property own the property? Does he own fee simple? If he only owns a life estate, he could move off somewhere and you'd never even know he died. Next thing you know is the remainder man's telling you to get out, and you're going, eh? Who are you? I didn't know there was a remainder man. I thought I leased it from the owner. Nope. You leased it from a life tenant guy, you're out. But at least you won't have prepaid a bunch more money. At least you'll quit paying rent.
Yeah.
Yes, ma'am.
Is it a good way to estate plan? Let's say you have 4 children and you say, I want my youngest to be the remainder man. That way it passes through the older 3, but they'll always have somewhere to live if the youngest person is a remainder man. Is it a good idea to use that for estate planning?
Well, life estates are wonderful for estate planning. As to whether to pick one of your children rather than pick your youngest, I'm not sure I follow you with the distinction. Here's what most people do. Most older people want to have the right to live in their property for the rest of their lives. And then they want it to pass to all of their children as remainder men.
Oh, so you can have a whole bunch.
Oh, you can have 10 remainder men. Yeah. When you create the life estate, you say who the remainder men are. And it can be a lot of them. If you were getting at, is it better to have it be the youngest one because it lasts the longest? No, because you see, when the remainder man gets it, it's fee simple now. So we're not talking about how long does anybody live anymore. That whole concept of how long somebody lived is over. Because the life tenant has died, and now we've got fee simple title and the remainder men, however many there were. Normally it's all the kids.
What if the remainder man is no longer remaining?
Is no longer alive.
You mean if he dies?
Passes to the estate of the remainder man.
Okay.
Under his will,
Yeah.
or under intestate succession if he didn't have a will. Remainder man is dead when the life tenant dies. Court will look at, okay, who inherited that remainder interest?
And it all
And
goes
that's who
fee
it's going
simple
to.
at that point too.
Should be somebody. You know, even if he hasn't done a will, our intestate succession statute is really broad. I've forgotten when it gets down to the absurd levels, but I mean, it's wife and children, and brothers and sisters, and parents, and then grandparents, and then it's into uncles and cousins, and I mean, it's pretty damn hard not to be able to find somebody. But if there is nobody,
Goes to
we
state.
talked a little bit about this cheat. It'll go back to the state.
It's cheap.
The word escheat, E-S-C-H-E-A-T.
Yeah, we did that.
when something passes to the state because there is nobody to take it. Okay, so, it's not marketable because you don't know how long a term you're getting the property for, how long you're leasing it for, how long you're getting a mortgage for, how long you're buying it for. Yes, ma'am?
I have a question. I was requesting the advice to put my home in a trust.
Uh-huh.
The home is in the trust, and the attorney says you should put the trust in the deed alongside with you and your husband.
Uh-huh.
So in case of one of two of you die, it's already, the trust is in the deed.
Okay.
Is that,
You can do that.
okay?
It's, I don't want to say anything contrary to what your lawyer is saying. There are a lot of estate planning lawyers in Florida who think that revocable trusts are wonderful, and I agree, they're wonderful. They're great.
Revocable.
However, lots.
Revocable.
Huh? Revocable trust.
Yes.
Revocable trust, all right. But most estate planning lawyers say, but it's not a good idea to put your house in there. Put all of your other assets into the trust, but not your house. And the reason they say that is because of all of those homestead protections we talked about for your house. And it's not real clear if all of those homestead protections apply once you put the property in a trust. That's the only reason. All your other property, great idea. Keeps it out of probate, gives you control. Automatically, the kids have it the day you die. You don't have to go through probate court for 2 years for the kids to get it. It solves a lot of problems. And it would solve those same problems as to your house. It's just that maybe in the meantime, during your life, while the property is still in the trust, perhaps it causes some problems, not problems, perhaps you give up some homestead rights that the Florida law gives you otherwise, and the courts are not real clear on which of those rights you forfeit when you put it in a trust. Okay. Yes, ma'am?
You said the life estate you can sell, mortgage, everything. Can you reverse mortgage?
I don't think any lender would take a reverse mortgage in that case. It's tough enough to get a lender to take a mortgage on a life estate as it is. To take a reverse mortgage, to me, would seem to be a doubly tough battle. To go to a lender and say, now, if your remainder man joins you, of course you can do all these things. You know, if the remainder man and the life tenant all agree, let's all sell this thing, hell yes, we can sell it if we all get together. The problem is we're talking about there's that interest hanging out there in the remainder man. And if you leave that interest hanging out there, that becomes fee simple upon the death of the life tenant, then the buyer from the life tenant or the lender who takes a mortgage from the life tenant is really holding the bag when the life tenant dies, because now it belongs in fee simple to the remainder man. But if the remainder man joins and says, sure, let's put a reverse mortgage on there so mom and dad, you can be drawing money for the rest of your life, that's fine. But then the mortgage is on there too when the remainder man takes it, if the remainder man joins. But I would be stunned if you could get a reverse mortgage. Frankly, I'd be stunned if you could get any mortgage at all. But what we're talking about here is what's legally possible. It's legally possible to get a mortgage on your life estate. Practically, marketably, nobody would touch you with a 10-foot pole. No sophisticated lender would touch you with a 10-foot pole. No lender who did title work and determined that all you had was a life estate. Okay, enough time on that, I think, or maybe too much. We're going to have a quiz. We're going to have a midterm next week. Some point next week, I'm not sure when, but we're going to have a midterm exam. You've pretty well seen what the format's going to be. I'm not sure at what point during the class we're going to do it. I don't think it'll be first thing. Some point during the class we'll take an hour maybe, and we'll do a midterm, and then we'll get back to completing the work assignment. But this is kind of the format, and it'll be longer than this, but it'll be questions like this, and it'll be questions on things that we have talked about in class, probably in your text too, but it won't be on anything that's in the text that I skipped in class, because that meant I didn't think it was important, and therefore I won't hold you responsible for it. Yes, ma'am?
For the midterm, will it be based on the first 2 classes readings, or will it go to the reading that's for the third class as
It
well?
will not go to the reading portion for the third class that we have not yet discussed. what I'm getting at is the first 2 chapters we're going to take up next week, if we get through this stuff, are on a real estate contract. And we're going to go through, it's chapters 10 and 11, but we skipped this time. Chapters 10 and 11 are the first 2 things that we'll do for next time. It's a real estate sales contract. I'm going to send you a form for the real estate sales contract a couple of days before class like we've done here. I am hopeful that we will be able to discuss first the real estate contract and go through it. And if we do, that may be on the exam too. But it won't be on the exam if we haven't gotten to it. And I'll kind of know that at the end of today, because if we've got 3 chapters left over, and that's what we'll have to do next class in the morning, trying to stay with this. We're going to have a hell of a time finishing this book. 600 and some pages to do in 5 sessions. I mean, we're talking about 120 some pages easily per term, plus time for the tests. It's going to be tough. So I'm going to push it pretty hard today if I can to try to keep it moving and get back on the schedule where we have completed everything for your work assignment today. Hopefully we will, because we're not going to have any quiz time or exam time today, and hopefully we get back on schedule for next time. Having said that, first chapter for today. Nope, I'm wrong. Not the first chapter of our reading assignment, but the portion of our last assigned reading session that we did not cover was the tail end of chapter 5. We're going to do that first, and then try to move on into the assigned chapter for today. Chapter 5 was something called co-ownership. We discussed at length in chapter 5, tenants in common, tenants by the entirety, joint tenants or right of survivorship. All that stuff made good sense as co-ownership, which was the name of the chapter. 2, 3, 4 people at the same time owning a piece of property, yeah, that's co-ownership. Interestingly, the text continued in this chapter of what it called co-ownership, and went into what it calls a real estate syndicate. Honestly, I've never heard that term. But what it talked about was a bunch of people getting together to invest money, to let's go buy a piece of real estate together for profit, and call that a real estate syndicate. I think the topic we're about to discuss is better described as how are we going to hold, I mean, we're talking about more than one person, of course. We're talking about several people together, normally, but not always, as we'll talk about. But to me, the topic is better framed as how are we going to hold title to this piece of real estate? And how are we going to be organized, assuming, we're assuming that we've got a group of people here, and that's the concept of this chapter, is a group of people getting together to invest together in real estate. So that's why they call it co-ownership. But this latter part is, to me, how are we going to hold title, and how are we going to organize our relationship of us investors to each other. We're going to follow to some extent the chart in your material on page 95. That's page 95 of the 7th edition. I'm not sure what page it would be, but it should be nearby, and those who had the 6th edition or the 8th edition. It's a chart of what it called the real estate syndicate, and it goes down the side and it gives you corporations and LLCs, etc., and what do they mean, and then it gives you kind of columns of what they talk about. We're going to talk about them kind of following the order of that chart, and some of the attributes that are in that chart are pretty relevant, and some I think aren't. Let me say first, as we look at the chart, left-hand side is going to talk about the type of entity we're talking about. It's pretty obvious, and we'll go through those. It talks about liability. And I want you to understand what we're talking about in liability here, really. I mean, you can discuss all of the gazillions of things that an owner of property could be liable for. But what we're really talking about here is personal injury liability. What happens if somebody gets hurt on a piece of property? Who's going to be responsible for it? And secondly, debt. If the owner of the property, meaning the entities that we'll talk about, has incurred debt, who's responsible to pay that debt? That's liability. What if somebody gets hurt? Or what if we have some debts, who has to pay them? The third column is taxation. This is not a course on taxes. We may touch on that briefly, but it is not, as far as I'm concerned, it's not something you're responsible for. It's something that will help your accountant and your tax advisor make a decision of what's the best type of entity for you. But I'm not a tax lawyer, and I don't expect you to be, and we're not going to explore that stuff at length, of like what type of return do you have to file and all that kind of crap. We're not going to go there. But it sort of helps make a decision as to what type of entity you want. And then lastly, it talks about the number of investors. How many people can be in this syndicate or this co-ownership that we're talking about? And it's kind of hilarious here that in the first one it starts out with one. It says we're talking about a real estate syndicate of one person. It's kind of way off base. But how many people can invest together in this method is what we're talking about. There are a couple of other attributes that I'm going to go through later and tell you quickly. How do you form these things in Florida, and what's a record, and who manages them and stuff like that, which you're not really responsible for, but I just want you to kind of hear it. But I want to go through each of these types of entities and tell you, as to these attributes, what I think is important and what I think will help you make a decision on how do you go. The first one here, it calls sole proprietorship. Now, sole proprietorship, again, implies one person. Yeah, but here we're supposed to be talking about groups of people. What this really ought to be is individuals holding as tenants in common, as we talked about, or as joint tenants of right of survivorship, or as tenants by the entirety. This is individual people owning title in their individual names. And, you know, the rights is between them are determined by the, as we talked about, whether it's right of survivorship, whether it has to be husband and wife, stuff like that. But we're talking about individuals. So rather than sole proprietor, this ought to be individual ownership. That's what this is all about. And if there's individual ownership, there is unlimited liability for everybody. Everybody who's an owner has unlimited liability if somebody gets hurt on the property. Not limited by the value of the property. There is no limit. Somebody gets hurt with damages of a couple of $1 million on your $10,000 piece of property, well, that's too bad. You can be held liable for a couple of $1 million. Whether you have it or not is a different issue, but it's not just how much is the property worth. It's unlimited individual liability. And of course, if you sign up a bunch of debt, the amount of debt that you sign up is unlimited. And you're liable for the whole debt. Now, taxation. Yeah, that's wonderful. It's taxed only once. Of course, we all know that. It's on your tax return. It's taxed one time by the owners. Of course, there's no gimmicks or benefits that you're going to do tax-wise by owning the property individually. And it talks about the number of investors. It says one. Well, we're talking about co-ownership here, so we're talking about at least two. But we could be talking about 3, 5, 20, 100. Technically, it's possible to have 100 owners. You could have A and B and C and D3 and B4 and all these individual people. And we're going to talk about an example of that later when we get into condominium ownership. But it's unlimited in terms of the number of people. That's plain old individual ownership. The first real entity then we're going to talk about, the first option that most people think about is, okay, if I'm going to have some sort of a structured ownership of all of us, what's the first thing we could do? And the first thing is a corporation. Everybody thinks about corporations. Know, if you will, that under Florida law, every corporation is required to have in its name, and I'm not telling you this for you to form one, but I'm trying to help you recognize when you're dealing with a corporation. By Florida law, any corporation must have in its name either the words incorporated or Inc., or corporation or corp, or company or co. Have to have one of those. Florida will not let you form a corporation unless you do one of those things, and the purpose is to tell the public they're dealing with a corporation here. Now, there is great limited liability in the corporate form. It is the biggest reason that people do corporations. Nobody is liable, no individual is liable if the property is held in corporate form. The materials talk about the shareholders are liable only up to the amount they've invested in the stock. Yeah, you lose your investment, but as a shareholder, you don't undertake any personal liability if somebody gets hurt there. And you don't undertake any personal liability for debt unless you agree to undertake that liability for debt. Now, in all these cases we're going to talk about, whether it's shareholders, whether it's limited partners, whether it's members of an LLC, we're going to say in each of these cases that these people, these investors, are not liable, but they are, of course, liable if they sign and agree to be liable. Know, if you would, in all these cases where we say these investors are not liable for debt to a bank, for example, well, they're not liable for that debt unless they agree to be liable. And very often the banks say, we're not loaning this money just to the corporation. We want all the stockholders to sign a guarantee of this loan. And of course, if you sign a guarantee, you're liable. But what we're saying is, if you don't, technically all by itself as being a shareholder in a corporation, that does not make you liable for the debts of the corporation, does not make you liable for the injuries caused by the corporation. The shareholders of General Motors are not liable when people sue General Motors for airbag deficiencies. The officers aren't liable, the directors aren't liable, and the stockholders aren't liable. That's wonderful liability shelter in the form of a corporation. And it's called a liability shelter. Yes?
Unless there's gross negligence, right?
No.
Like if GM, head engineer knew
Oh, okay.
that,
That's personal liability for a tort that individual may have committed a wrong against the people. If he's functioning totally in his corporate capacity, there is not personal liability. And I'd rather be on the defendant side of that. It helps establish liability of the corporation if you see the type things you're talking about where the chief engineer wrote to every board member and say, hey guys, these airbags are defective, we ought to do something about it. And the board says, no, we're not gonna. The board usually says it's cheaper to defend the lawsuits than it is to fix all the airbags. All of that is wonderful evidence to hold the corporation liable and maybe to have punitive damages that we're going to talk about later against the corporation. But in and of itself, it is not normally adequate to establish personal liability of an individual acting in his corporate capacity. Officers, directors, and shareholders are not liable in corporation. Okay, the downside. Double taxation, the material talks about. There's a tax detriment to being set up as a corporation. And all the double taxation means is the corporation makes profits and then files a corporate tax return and pays tax on those profits. And then there's some money left over. And then that money goes to the shareholders in terms of dividends, stock dividends, however you get the money out of the corporation back to the shareholder. And then it gets taxed again when those shareholders get it. So So everybody calls that double taxation. That's the downside of a corporation. Profits are taxed twice. Okay, the number of investors it says is unlimited. Well, that's for sure. How many people you sell stock to? Now, there's another type of corporation. And in all respects, it's exactly the same as what we talked about in corporate structure. And it's called the sub-S corporation. Subchapter S is what that means. That's a certain subchapter of the Internal Revenue Code is called subchapter S. There is totally limited liability, just like we said. Officers, directors, shareholders are not personally liable unless they decide to be and sign on to some debt. But unless they step up to say, okay, I'll be liable, they're not. And this type of corporation, the profits are taxed only once. There is no corporate income tax. All of the income flows through to the shareholders and gets taxed on the shareholders' tax returns. And this sounds like a wonderful home run. Well, hell, why aren't we all sub-S corporations? Because there are lots of limits on how many shareholders you can have. The first is it can only be 75 of them. And then they can only be U.S. taxpayers. And then they can only be certain types of individuals. They can't be entities. So there are lots of restrictions that say, well, this type of corporation doesn't work for everybody. So, of course, General Motors can't be one. Too many shareholders. Subchapter S corporations are small businesses that would like to have the liability protection provided by the corporate form, but would not like to pay taxes twice on their profits. So they organize as a sub-S corporation. You form it just like any other corporation, and then you file an election one time with the IRS called a sub-S election. Hey, we'd like to be treated as a sub-S. That's it. Year after year after year you are. You don't have to file that election every year. You file it one time, you're a sub-S forever.
Does it restrict how much of your profit has to go directly to?
No.
Okay.
No. No, there's no rule about you have to distribute profit. At the risk of getting too far into taxes, let me say though, whether you do or you don't distribute your profits are taxed to the shareholders anyway. Okay? So it's not taxed based on how much of your profit you distributed to the shareholders. It's based on, basically, just like the corporate determined what is your profit. All of that gets taxed to the shareholders, whether the corporation distributes it or not.
Okay.
Okay? Okay.
So if you're a C Corp, you can change to be an S Corp, like if you're a C Corp for 5 years?
You can change back and forth. You can elect to be a C Corp if you want to. This year I want to be an S Corp, I want to be a C Corp.
And I know there's...
I think there are certain restrictions about you can only do it.
Yeah.
Like if you elect this way, you got to stay that way for 3 years or so. There are rules about that. And the accountants know them all, and I absolutely don't. But I know you can go back and forth, but not without restrictions. There are some rules about that. And you said C Corp. The first type of corporation we talked about is a C Corp. These are tax rules. Florida, when you file a corporation with Florida, you set up a corporation. It couldn't care less whether you're a C Corp or an S Corp, because that's taxed all. You're a corporation. But a C Corp is a regular corporation taxed twice, like we talked about under the Internal Revenue Code, and an S Corp is taxed once under the Internal Revenue Code.
But you still have in an S Corp, you pay the Florida corporate tax on that, or no?
Say again?
On an S Corp, you pay Florida corporate tax, or no?
No, you don't. There is no corporate tax. There is no tax at the corporate level.
I have a question, and I'm sorry to go back about real estate syndication.
Go back to what, I'm sorry?
To the term real estate syndication. I have a big doubt on the terminology. Before 2008, I remember that you couldn't, as a broker, as a developer, promote your property or make your offering memorandum extended more than people that you really have a relationship with, or you have with family, because it was considered to be, for you to be selling securities.
Yes, believe it or not, in the next chapter, at the end of the chapter, we're gonna talk about exactly that item, exactly that. That has nothing to do with the structure of the entity. That has to do with whether the offering, so to speak, is a security, and whether you are under the security laws. What we're talking about here is not the security laws.
Yeah.
Okay.
But they call
But the
it-
term syndicate, that's candidly, that's why the word syndicate bothers me.
Yeah.
Syndicate sounds like an investment contract that ought to be registered under the Securities Act and the blue sky laws and all that kind of stuff. Yeah, that's what a syndicate sounds like to me. That's not what we're talking about here.
Okay.
It can be, I mean, it can be, but not everything that I'm talking about is a syndicate by any means, by any stretch, in terms of what I think of as a syndicate, which I like you, think of as a security, an investment contract that has to be registered or have certain exemptions, which we'll talk about.
Okay.
But that's why I think it's a bad word. I think it's a horrible word, but that's what the book calls it. To me, this is, frankly, even the book calls it co-ownership. I don't think it's co-ownership. In law school, we had a course simply called corporations or business organizations. Business organizations, frankly, to me, is probably the best word for this. These are types of business organizations to determine what type of, but since we're talking about real estate, what is the best type of business organization to own your real estate? And in all these cases we're talking about, it's the owner of the real estate. It holds the deed. It is to whom the property is deeded. It is how title is vested. We're assuming in all these cases that the corporation owns the land, or the S corporation owns the land, because that's what we're talking about here. Okay. We good?
Perfect.
Not good?
No, perfect.
Okay, thank you.
I agree with you 100%. This word is distracting. And
It's a bad term. Forget it. These are business organizations. That's what we're talking about here. Okay. The next one the material talks about is a general partnership. These are really rare. They are rare because a partnership is an entity, but every partner has unlimited liability 100%. So it doesn't really do any good to have an entity here. You might as well, if you got 3 partners, but for issues of divorce and other problems like that, you might as well have title held by A, B, and C, 3 guys, 3 ladies, A, B, and C, as have a partnership named 3 ladies, a partnership. Everything is the same. All 3 of you are liable for everything. You're liable for 100% of the debts. You're liable for 100% of the liabilities. About all you've done is created a name so that you can have title held in that name, rather than Bill and Bob and Mary. Well, we'll call it a partnership. But it basically 100% liability. Now, you're taxed only once, but of course you were taxed only once as individuals too. So it really doesn't gain anything for anybody in terms of ownership of real estate, other than it's sort of a way to hold title in a trade name, so to speak, as opposed to in the 3 persons' names. Happy Farms, as opposed to Bill and Bob and Mary. Happy Farms, a partnership, but they're all still 100% liable for everything, and it just doesn't really gain a lot, and therefore you're going to find virtually never used in Florida for the ownership of real estate, because it just doesn't offer any benefit. Everybody's looking for limited liability. Everybody's looking for some sort of a shelter. Not necessarily a tax shelter, but a shelter of their liability. And this one just doesn't get it. But what does get it is a limited partnership. And that's next. Limited partnerships are very popular in Florida for the ownership of real estate. And the reason is, only one partner is liable. That one partner that's liable for everything is called the general partner. Everybody else is limited partners. Limited partners aren't liable. And know, if you would, that that general partner who is liable for everything is usually a corporation. And usually that corporation has 0 assets. So the philosophy is, go ahead, take your best shot. Go ahead and shoot at the general partner. The general partner has nothing. So you form what we call a shell corporation, which means a corporation like any other corporation, but you don't give it any assets. And you let it be the general partner. And it's like offering up the lamb. Great. He's liable. If it's a he, that's a bad thing. He or she, you don't use an individual. That person would be, you can, but who wants to be that person? So you form a corporation to be the limited partner, to be the general partner, I'm sorry. Form a corporation to be the limited partner. The general partner is liable for everything. The limited partners are the investors, and they're not liable. And it's taxed only once. So it's got that benefit of a S-corp, but it doesn't have the limitations. There can be hundreds of limited partners. There can be thousands of limited partners. There's no limitation on the number of partners. There's no limitation on the types of partners, like we had those restrictions in an S-corp. Limited partnership is great. And for years and years and years, all through the 70s and 80s and even into the 90s, this was the favored way of owning title to real estate. Initially in the 70s, it was a little tough to use them because all of the offshore entities that everybody thought did nothing but deal drugs were formed in the Bahamas. They were all named limiteds. And all Bahamian corporations are named limited. In fact, under the European system, the British system, limited means a company. They call their companies limited. And everybody thought these were offshore companies, these were bad, these were the drug dealers, these were the people that didn't want to register under a law. So when you formed a limited partnership in the 70s or early 80s, the banks didn't want to touch it because it had a bad reputation. Finally, they got over that, and that was now it is accepted as a very proper, very intelligent, very useful, excellent way to hold title to real estate.
Isn't there some sort of provision where if some of the limited partners started acting as general partners, they assume liability?
Absolutely. Limited partners' role must remain limited. There are cases after cases that determine what can a limited partner do without de facto becoming a general partner too. That's what's really happened. If a limited partner acts outside the scope of the limited functions that he should be performing, then he becomes a general partner and therefore is liable to. And that's how liability is established. When you form a limited partnership, you designate with the Secretary of State who the general partner is. You don't designate who the limited partners are. We're going to talk about that in a minute. And the purpose of that is for everybody knows that's the general partner, he's the one who's liable, he's the one I get to go after. But these secret limited partners, if they actually take over control and start running the business and dealing with people on behalf of the limited partnership and signing documents and signing checks and doing all kinds of things that are inconsistent with being just an investor, then the courts say, you may not be a named general partner, but you have functioned like a general partner, and therefore we're going to hold you liable like a general partner. So yeah, you got to, and you know, that same concept applies in a corporation. If a shareholder starts running the corporation and starts signing checks and hiring and firing people and dealing with the public and everything, then the public is entitled to rely upon the fact that he has corporate authority. And if he were to overstep that authority, conceivably he could have some liability.
So how would you run a company under a shell corporation without running the company?
I'm sorry, run
Sounds
a
illegal.
company under a shell corporation?
How do you
just don't
run-
give it any assets, period.
Okay.
Has officers, has a
Okay,
president,
so it
vice
does have
president,
all that.
secretary, treasurer, board of directors, all that kind of stuff. It just doesn't own anything.
Mhm.
And it doesn't even have to have a bank account with any money in it. Because the limited partnership has the bank account. And it's the limited partnership's bank account and funds. And all the general partner's doing is signing checks on the limited partnership.
Okay.
But it doesn't mean
The
that the
officers
general
of
partner
the
has
general
assets.
partner.
I'm sorry?
It's the officers of the general partnership
Are in, exactly. The
that are signing the
well,
checks and all that.
the officers of the general partner corporation
Mhm.
are signing as officers of the general partner on behalf of the limited partnership of which it is the general partner. And in fact, when you structure a document, let's say a mortgage, when you structure a mortgage by a limited partnership, you say, this is a mortgage by XYZ Limited Partnership by ABC Corp., its general partner, by Joe Blow, president of the general partner,
Gotcha.
which was the general partner of the limited partnership. So it's kind of a two-tier thing, but it works. And the point is, you can have assets. I mean, you can put some assets in there if you want to. It's just that whatever assets you put in there are exposed to liability if somebody gets hurt and sues. Yes, sir.
So if you were gonna buy the property next door, the vacant lot,
Uh-huh.
and build a building there, you would set it up this way?
I would set it up as a limited partnership. I say that because that's my experience and what I'm used to, and I know how they work.
And then you would have a shell
For a corporation
as a general partner?
to be the general partner, but give it no assets.
Mhm.
But what I want to say to you is what we're going to talk about next, the LLC, that's the darling today. And everybody likes LLCs. And accountants are pushing LLCs. And slowly, people are starting to use LLCs as investment vehicles. And it probably will become the primary thing in the future when people get used to them. It's just that right now, people aren't used to how they're set up. And we're going to talk about them in a minute and how that structure is different and how their terminology is kind of weird. Nobody's used to that. They don't have a president.
Mhm.
So people will say, well, what do you mean you're the managing member? What the hell does that mean? You know, they're just not used to it. They work great.
Cause there's
But
a
they're
developer
coming-
in Miami, I looked at a couple of his properties that he owns and vacant land, and you have to go through like 10 companies to finally get down to his name.
Yeah.
And-
And sometimes you'll never
And he
find
hired
it.
like, I think the company's called like Creative Corporations, and they create this, like, it just seems so many layers to,
You can set up 8 or 10 layers of ownership, and sometimes the real guy will never be there. You may never see Warren Buffett's name anywhere, but somewhere down at the bottom there, he owns the ownership interest of this, which may be a limited partner in this, which limited partnership may be a member in an LLC, which may be a part of a limited liability partnership, on up the ladder. You can stagger it all the way down, and the point is that the ultimate real owner you'll never see. Now, frankly, with Donald Trump's corporations, when Donald Trump's entities go borrowing money, you don't see Donald Trump signing as president. He's just back there pulling the strings. He's the puppeteer. He's got officers. He's got people that work for him. People that work for these entities. But at the very bottom, you get to the end of it, somewhere down there, he's the real investor, but he's got to be careful. Because if you exercise too much control, if you show the public, I'm the driver here, it's all about me, I'm really in charge, even though I'm just this little guy down here. The public gets to think that you are the person that's liable, and then you can establish, a good personal injury lawyer can paint a case of, this guy was calling all the shots, I want him to be liable. And then, of course, it becomes your job to say, no, I'm just the guy way down here. But yeah, you can structure 8 or 10 levels of ownership, and it's often done. And frankly, it's to obfuscate the situation for personal injury lawyers to make it harder to get at the guy. In corporate law, the term that gives limited liability to the officers and directors is called the corporate veil. And when you try to establish personal liability of officers or directors or shareholders, you are trying to pierce the corporate veil. And that's a term that you hear used all the time. Do we have any basis here to pierce the corporate veil and get at these people individually? Because
like
the
a
entity
shield.
has no assets? It's tough. And that's the more, and the more veils that you set up at each of these different levels, the harder it is to pierce each one of them to get down there to get to the person that you're really after, the person who really has the assets. Thank you.
Hold on a second.
Yes, sir.
I think she had a question first, and then you still had a
Yes.
question?
Hey,
I did. I didn't see you back there. You don't.
I'm sorry, we have one
We have a couple
Oh, I'm
questions.
sorry.
questions or people didn't sign? Go, okay, go ahead.
I just wanted to share something with you, is real estate investing, when you have sophisticated investor, LP companies are the ones that you really would like to pursue. As a GP, as a general partner, you want them to be as quiet as possible, and for example, with the pension funds, or if it's an insurance company that will be your investor, they don't even want to know they're giving you a mandate for a blind pool. They don't even want to know the name of the investment. So it doesn't constitute at any point that they are becoming co-GPs with you. So you want to be transparent, you want to have interaction with them, but you want them to be LPs and not interfere with your investment decisions and investing the money or divesting the money. So that's why it's so popular in real estate investing when you use institutional money, for example.
Okay.
Good.
Go ahead, Fred. All right, so forget it.
Yeah, no, go ahead. When you do the shell corporation with an LP, what happens when you go for a loan and they need a personal guarantor?
Oh.
And the person has no access to it?
The bank's going to require whoever it believes it needs for underwriting to make sure it gets paid. It's going to call for the limited partners to guarantee the loan.
Oh, the people
They
who are
just
hired-
became liable, okay? If they sign a guarantee, they're liable. Signing a guarantee of a loan alone, though, does not make you a general partner. It makes you liable for whatever you sign. A limited partnership may have 20 loans, and not necessarily is every limited partner going to be called upon to guarantee all 20 of them. The little ones, the bank probably won't care. The big ones, they're going to want all the limited partners to sign a guarantee, but that does not make those limited partners general partners and does not impose upon them general liability for personal injury or for the other loans that they didn't guarantee. When you sign a guarantee, you guarantee one certain debt, and that's it. Unless it says otherwise, unless you sign a guarantee to Bank of America that says, I'll guarantee all the debts of this limited partnership. Still didn't make you a general partner, but it sure gave you a lot of liability. But if you don't exercise control, if you don't get too involved in management, you can still be a limited partner. And you'll still have at least that benefit of if somebody gets hurt on the property and sues the limited partnership, at least you're not going to be liable for that. Because of the two types of liability we talked about. The bank loans are what you addressed, of course, and if you guarantee them, yeah, you're liable. If you don't guarantee them, you're not, as a limited partner. And we talk about the personal injury liability. Limited partners are not going to be liable for the personal injury. General partner is, but if it's a corporation that has no assets, so what? Okay? All right.
Who determines,
Yes, ma'am.
who determines how general can you become when you sign a mortgage? Is that on the documents of constitution of the corporation? Because once you sign an agreement that you're gonna be liable, I mean, you're gonna be responsible for a mortgage on doesn't that make give you some sort of saying on like as a general partner?
No, unless you exercise that function. You may want to have some say-so because I guaranteed a loan.
Yeah. How do you establish that? I mean, you wanna say so, but you're putting your money, but you don't have anything to say, just not to be liable, you know, it's
An operating agreement.
That's, realize if you would that partnership meetings are not held in the sunshine like meetings of the city commission. You exercise as much control as you believe you can and want to, and you hope like hell you don't step over that line where you're acting like a general partner and becoming liable. As the investment manager, you want the limited partners having no say-so whatsoever. As the investment manager, you think you know everything, you want to call all the shots, I know what's best here, I know how to run this investment, I don't want to hear from the limited partners. But a limited partner guaranteed a $10 million loan, he wants to have some say-so over how things go. And that's the interplay within a business organization of the relationship between the investors and between management. And I couldn't begin to give you an answer of this is how it always works. In some limited partnerships, the limited partners are really driving. In others, all they see is they get a K-1 every year for their tax return and hopefully they get a check. And that's all they know, and sometimes that's all they want to know. As long as things are going well and the manager's doing a great job, most of them have the smarts to keep their mouth shut and stay out of management. It's when it's going poorly. And when the bank is calling on the guarantee that you're over there shaking on the managers, oh, come on, what's going on here? But you gotta be careful that you don't start taking over control, because if you do, then you, by having control, conceivably accept some liability. But it's all over the board as to the amount of control that limited partners have. Now, I'm gonna say one thing here for a second that I was gonna mention later, but I think it's important to realize. And this is going to apply as to the LLC we're going to talk about in a minute. Realize that if you would, that in all of these cases, sometimes it's one person, period. The book talks about the syndicate and co-ownership and how do we put all these hundreds of people together. Sometimes it's one guy. One guy in a limited partnership. He's the only limited partner. He's the only stockholder of the general partner corporation. He's the president of the corporation. One guy. Serves in all those functions.
He just doesn't want the liability.
He wants to have a limited partnership. He wants the liability shelter of a limited partnership. He doesn't want to own individually and have unlimited liability. He wants there to be no liability. So he's just everything. And it all works just fine. And there are a lot of them like that, so that what we're talking about here is business organizations, not necessarily how do hundreds of people get together and own a piece of property. Sometimes it's two guys. Sometimes one's the money guy and the other one's the doer. Okay, yes, sir.
Why are they all formed in Delaware usually? You would see like Delaware.
The reason is that hundreds of years ago, Delaware was one of the first states that had a corporate law that was very beneficial to corporations and had a lot of case law where the courts ruled what the rights of shareholders are And the Delaware law became very well known, not vague legislation, but clear legislation with lots of court cases interpreting the rights of shareholders, the obligations of directors, the obligations of officers to the board, liability, all that stuff was all very clearly outlined, so everybody formed their corporation as a Delaware corporation. It still happens some. And a lot of it's tradition. A lot of people think, you know, hey, Coca-Cola is a Delaware corporation, maybe I should be too, you know? Understand, it doesn't mean that you even have an office in Delaware. Now, I take that back. You have to have an office where somebody can serve you if you get sued. But it doesn't mean you run your business there. I wouldn't be surprised if Target, I wouldn't be surprised if Target is a Delaware corporation, but its corporate office is in Minneapolis.
Yeah.
And, but it's, when we say a Delaware corporation, that is the state with whom you registered the corporation when you first formed it, where you filed your documents. Doesn't mean you can't do business all over the country. It's the law of the state where you filed your documents and initially created your corporation.
Going back to the general partner and like the shell corporation, a lot of becoming a general partner is perception of what you do, right? So if you were to form a shell corporation and the name of it resembled a particular individual, would that give a perception that this one is a general partner? So if something happened, could I be, like say I formed a shell corporation, it was Saunders Inc.
Yeah, yeah.
And I'm not the general partner, however, that's just the name of the shell corporation.
Lawyers will tell you
Don't
not
put your name
to
in
do that because it helps pierce the corporate veil.
Okay.
It helps give PI lawyers a shot at saying, I was dealing with this guy, I don't care he's got some corporation. The name was Trump.
Yeah.
It's Trump, you know, I was dealing with Trump. And Trump's trying to say, no, it's Trump LLC of Boardwalk Limited General Partner. You know,
So avoid
okay.
the connection.
But yeah, so it can help you grow your business if your name's famous and you do well, but it also gives you potentially some exposure to liability. Not for corporate, not for debt, okay? But for personal injury.
Okay.
Debt is going to be determined by corporate law and by who guaranteed the debts on paper. In other words, it's going to be paper. It's not going to be perception.
Okay.
But perception can be big on liability. I thought I was safe going on Trump's property because the Donald was managing the thing. Everything sure was bound to be fine. I trusted him.
Yeah.
And he's saying, that was by my LLC. Okay. Yes, ma'am.
One of the reasons why any attorney will tell you that to avoid your name is because you cannot trademark or register your name. It's very complicated to register a name per se. You can do it, but it's complicated. And that's the only way that you don't pierce the veil if your name is registered. If not, that is the perception that you are the one running the business.
So you're saying you have to register your name?
We tried in our company and we were restructuring, and our CEO, his last name is very appealing and it's very well known, and we were looking into using his last name as our new brand. And all our attorneys said, we can do that, but registering his name is going to be so difficult, and it's the only way to protect him personally for not piercing the corporate veil, and he might end up being liable as a person because people, it doesn't really matter who's dealing with, it's thinking that he is the person that they're dealing with, like Trump.
Sure.
So we decided to change it because of that reason, and it was a big restructuring of the name.
So I guess going from that, like, say if I want to have my name on I want to build a brand off of my name, well, not just generally speaking, how do you avoid that? Do you have to get your name registered at that point, like to protect yourself as an individual?
You can form a corporation in your own name.
Yeah.
You can be Joe Blow Inc., you know, I mean, my corporation, I practice law as a corporation. The name of the corporation is Steve Genestra, PA. I'm liable anyway because the Florida Bar says I'm liable for whatever I do.
Yeah.
But if I sign a lease as a corporation, only the corporation is liable.
Got it. Okay.
But personally, I'm liable anyway, and sure everybody gets to say, I didn't think I was dealing with a corporation, I was dealing with you.
Yeah.
I was dealing with you.
So
They're gonna come
does
after me
that
anyway.
pierce that corporate veil?
But I wouldn't want to form a corporation named Legal Eagles, Inc.
Mhm.
If I thought that I had worked hard for 40 years and I thought my name meant something and my name would bring me clients, well, then I wouldn't want to go crank up Legal Eagle
Yeah.
that people would say, well, who the hell are they? You know, so you may want to use your name. Stiles Corporation, Terry Stiles.
Yeah.
Stiles Corporation. Technically, theoretically, that gives Terry some risk.
Hmm.
People may say, I thought it was Terry. I thought I was dealing with Terry here. But the name means a lot, and the name brings in clients, and the name adds benefit to a project and everything. So but I guarantee you, somebody has told Terry somewhere along the way, you're really running a risk having your name hanging out there and having people shoot at you.
Mm-hmm.
And I guarantee you Terry's answer was, and that's what insurance is for. Thank you very much, lawyer, for your good advice. I'll buy $10 million of insurance from Lloyd's of London, and I'll take that chance because my name is worth it.
Okay.
So these are the, you know.
He probably had the logo to it,
Mhm.
so he went ahead and logoed and registered as a combined name with the logo, so that gives him some protection.
But surely in those cases we talked about, it's not Terry Stiles individually though on a project. You know damn well it's going to be the Stiles LLC of downtown Fort Lauderdale, you know. I mean, it's still going to be an entity, but it may have his name on it. It's not the same as doing business individually as we talked about. It's doing business in the name of whatever entity you talked about, whose a person's name happens to be on there to lend credibility and the likelihood of success and the attraction of business, but there is some risk to that person. Okay.
One more question.
Yes, sir.
Is there like significant case law where it seems like, you know, people are setting up corporations, and, you know, just to mitigate risks, and it seems like, you know, it's really someone's personally liable for something, and the corporation is, you know, just like you said, it's just a veil. Is there significant case law that shows that people pierce the corporate veil and get to the person that's really liable, or not really?
No. There is case law to talk about what, and we touched on this a little bit before, what egregiously terrible, willful, wanton thing might you have done in the corporate name such that we ought to hold somebody personally liable? But not the mere fact that the corporation had no assets is therefore the right to go after individuals.
Okay.
If a corporation injures somebody and it has no assets, well, that's just too bad. If everybody who was acting for the corporation was acting properly in their corporate capacity and not doing anything willful, wanton, egregious that shocks the conscience of the court, there are cases like that, but they're rare, and they're not triggered only by the fact of, oh gee, the corporation has no assets, that's not fair. Okay.
But in like,
All right.
and with contractors and construction defects, they almost always sue the business and the owner person. They'll go ahead and sue the owner personally as well.
Oh, yeah, and it just, of course they're gonna sue the individual anyway. What we're talking about here is whether or not they're successful. Whether or not you can convince a judge that the judge should issue a judgment not only against the corporation, but also against an individual. Personal liability lawyers, if something goes wrong out in the hall here today, they will sue every one of us here in the room. And let us figure out who ought to be responsible. That's not the problem of the personal injury liable lawyer trying to figure out who should be liable. He just wants somebody to be liable. And he's going to take shots at everybody he possibly can. And maybe he can establish individual liability